Hello folks, welcome to Lexi IAS Academy. In this video, we will be discussing the current affair compilation of July month for polity. This is specifically only from prelims perspective, so we will see the topics from prelims perspective and we will learn more about the topic based on your questions. We will see or learn more on this based on the question patterns that we will discuss. Alright, let's get into the topic. We will be discussing in today's video about special packages, auditing of local bodies. We will be discussing about your CBI. We will be discussing about the Constitution of India and France comparison. We will look into the cabinet committees. We will be discussing about the constitutional morality, and at last we will be discussing about your Article 341. This video is presented to you by your faculty Sushma KP. Let's get into the video. Recently, Chief Ministers of Bihar and Andhra Pradesh have asked for special packages for their respective states. What is this special packages? First and foremost, understand that this is more like an incentive apart from what your finance commission has told to give the center to the states, that is your devolution of funds. Apart from that, this is an extra discretionary fund, which means alongside this, that is what Finance Commission has told, this is another extra set of grant given to the respective states, and this is completely discretionary, which means it is not bound to be received by states on certain points. Let's say I have 3 checkpoints, my state meets all the category, you have to give me. No, it is not based on the need. Understanding, this is on the discretion of the central government to the state government. Here your Bihar government ke liye in your budget 2024-25 it was announced that for irrigation and flood mitigation 11,500 crores to projects such as the Kosi Meki interstate project for Bihar is sanctioned. Now look at this Purvodaya Vikas B Virasat B plan for endowment of rich states in the eastern parts covering your Bihar, Jharkhand, West Bengal, Odisha and Andhra Pradesh, so that these states can realize the economic development and be on line with realizing Vikshit Bharat by 2047. Understanding? This is with regarding to your special packages. Now understand, time and again I'm telling, this is merely discretionary in nature. It is not a mandatory thing that center has to give in case if this particular set of checklists happen. What are those checklists? Further down the video I will discuss. With respect to Andhra Pradesh Reorganization Act of 2014, they have told financial support of 15,000 crores announced in your budget of 2024-25. Also held for completion of Polavaram irrigation project and also for essential infrastructure such as your water, power, railways, etc. along your Visakhapatnam Chennai industrial corridor as well as in a Hyderabad Bengaluru industrial corridor. Okay, this is with respect to your Andhra Pradesh demand. Now, when you see with regarding to your special packages, one of the main things that it is given, your constitution itself has a provision for discretionary grants that covers from Article 371A to 371H. Like this is not again a permanent in nature. Okay, this is not of permanent nature. This is more of a temporary fix. Why this temporary fix is given? Because of their geographical and socio-economic challenges. Only to address this it is given. Which article deals with that? That is Article 282. Empowers both center and states to make any grants for any public purpose. Now when you see this concept like this, that is discretionary grants, is it good or bad? Is it helping the situation? Is it able to address your geographic and socio-economic challenges? One of the things that your states have realized is it is more aggravating the condition rather than solving it. More and more states are now asking the center for discretionary grants. It has now more of become like a mandate, or if in exchange of political favors, in exchange of supports, this has been started. At the same point of time, if it is so bad, then why do we give it? To offset the fiscal shock, that is, see for example, with respect to your Andhra Pradesh bifurcation into Telangana, at that point of time, it said that it had to come out of the shock because a majority of the revenue resource bearing things went towards the Telangana side, is at least it's what it claimed. To rebuild infrastructure during your relief measures, for example, your Tamil Nadu, when it gets hit by a particular cyclone, now in this case, see, cyclone Michajum. So what happens is a lot of loss, unexpected loss happens where the state has to recover from that shock. So this helps in mitigating that conditions. And also to channelize the resources for your poorer states. For example, your Bihar and all has claimed that it needs additional funds to make sure that it has to get people from absolute poverty out, means it needs this discretional grants. Like this, we have multiple advantages of it, but at the same point of time, what happens is instead of focusing on the long term solution, people get fixated on the short term fixes like these discretionary grants, which is where it leads to the disadvantages stemming from this. Let's look at some of the questions. Which article of the Indian Constitution empowers the center to provide special financial assistance to the states? That is your Article 282, like we discussed in the previous. Potential implication of providing special packages to states outside the Finance Commission. Strengthening of fiscal federalism. First, I'll read out all the options, then we'll discuss the answer. Weakening of the federal structure, increased economic growth, reduced regional disparities. Here, the answer is weakening of the federal structure. Okay, you are not trying here to improve any bond. This is but rather in turn, it is more of changing the nature wherein the states are now very much determined on getting that rather than having any long term fixes. Which of the following is a potential consequence of unequal distribution of special packages among states? Which is why I said states keep fighting amongst themselves for this. Promoting regional development, reducing regional disparities, exacerbating regional inequalities, encouraging economic growth. What it has to actually do, but what it is actually doing is exacerbating regional inequalities. Understanding? This is the answer. Which of the following is a criteria for providing special financial assistance to states under Article 282? Again, just because a state meets these conditions doesn't mean it has to receive it. There is no mandatory concepts here. Poverty levels, infrastructure deficits, disaster impact, all of the above. Like the examples that we discussed, all of this fits the category. The reason I gave you it also so that you can understand these all the points which will come under these. What is a potential governance issue associated with the provision of special packages to the states? Look at this, they are asking it with respect to governance issue. That is, once after, yes, now all states keep fighting amongst themselves for a higher discretionary grant, is what we discussed. Once they get that, do you think is it reaching the target audience? Is it serving the purpose? Or what exactly is happening? Effective utilization of funds, poor governance and leakages, increased transparency and accountability, reduced bureaucratic delays. The answer is poor governance and leakages. This again leads to your corruption. Understanding? So basically, the other three are supposed to be happening, but it is not happening. Rather, this is what is happening. So the answer is B. The next topic that we will be looking into is auditing of your local bodies. Recently, again, the news that came into why this topic was brought in was auditing of your local bodies becomes very important, so much so that it has to be on terms with international standards. When I say international standards, more than 40 countries are following this for their local governance. That is for their local democracy. That is for their local levels of your grassroots democracy. which is what is making them move towards a step of inclusive development. Center for Audit on Local Governance, or otherwise called as ICAL, was inaugurated in Rajkot, Gujarat. This is the very first of its type in India, and this is a very good thing to be starting on this step. Presently, if you see who is undertaking all the auditing of local bodies, who overlooks the auditing of local bodies, that is your CAG, Comptroller and Auditor General of India. Why do we need the ICAL? First and foremost thing is so that the panchayats and urban local bodies will be aware of the best practices and knowledges with regard to auditing. Why do we have to first of all do auditing? So that the public funds are not wasted and the public knows how their money is sourced and channelized. Second thing is to combat corruption. Third thing, now we say that this auditing is very much needed in local governance is because many a local democracies, that is your panchayats and municipalities, still are, let's say it was adopted around 30 years, so many decades ago. They are still using the same parameters. Even though it is of complete inconvenience, they are still sticking to the same parameters and there is no change. And the most mainly is lack of awareness to deal with all of this. So as to align with the global practices and assist the local governments in achieving your sustainable development goals and foster community engagement and address inefficiencies in the fund utilization of your local governance. So what are certain constitutional provisions we have? Article 243G, it speaks about devolution powers to the local bodies. 243J, maintenance of accounts by your panchayats. 243Z is maintenance of accounts by your municipalities. Again, here you will remember your 73rd and 74th amendments with regard to panchayat and municipalities, and you will also remember the 11th schedule and 12th schedule. Okay, these are some of the key things that you have to remember. Ministry of Panchayat Raj Development has begun or developed audit online application, whereas they can conduct the auditing for the panchayat and municipalities in an online medium. They won an award in World Summit on Information Society prizes. With respect to local governance, first thing is it is by your CAG for both municipalities and your panchayats under your examiner of local fund accounts or director of local fund accounts. And also in your WHO Alma Ata Declaration of Primary Healthcare, it has said that if at all healthcare has to reach, that is, if it has to be accessible by all or to access to all, then one of the ways that we can penetrates to the last mile or not is all dependent on bringing this healthcare to your local bodies. So for that, strengthening of your local bodies becomes extremely important. You have to make sure they are empowered, and to empowering them, one of the key crucial steps is bringing them under the ambit of auditing. Understanding? Now, for example, if you see schemes such as your Atal Bhujal Yojana, it is for your groundwater maintenance, recharge, etc. And that is which of the following is the key feature of the auditing mechanism for the local bodies in India? Look at this. The Comptroller and Auditor General has the power to audit the accounts of local bodies. Local bodies are exempt from auditing requirements. Auditing mechanism is seen by Ministry of Panchayat Raj. Local bodies are required to conduct self-audits. The answer is the CAG. Like we discussed, CAG is the one who audits the local bodies. What is the primary purpose of International Center for Audit of Local Governance? To provide training to local body officials on auditing standards, to conduct audits to local bodies, to set global standards for auditing local governance bodies, to provide funding to local bodies for auditing purposes. The whole point of ICAL is to set global standards for auditing in local governance. Which of the following is a challenge faced by the local bodies in maintaining their accounts? Lack of skilled personnel, inadequate funding, outdated accounting standards, all of the above. Again, I've given all these options just so that you can add it to your list. The answer is all of the. Constantly we hear this phrases in synonym with your CBI, calling it as a caged parrot. The issue is coming into the limelight, or we are discussing about CBI, is because West Bengal government has alleged that your center is constantly disregarding the federal power by unanimously or forcefully trying to put in CBI investigations into the state, even though the state has taken back the general consent. Now, under Article 131, the Supreme Court has reiterated that yes, see, the original jurisdiction is to address a dispute between the center and state, here with regard to the center and state, West Bengal state and the union government. The Supreme Court has to take a stance. Now, what happened exactly means CBI. Okay? States, each time CBI has to inquire into a particular issue, every time it has to enter a state, instead of wanting to take consent from them, there is something called as general consent. If a state has given general consent, which means CBI doesn't have to take permission from the state each time it has to enter the state for any investigative activities. CBI is the apex investigative agency in India. So whichever states give the general consent, then CBI doesn't have to ask it time and again for every time to the states. But the issue is, for states who have revoked the general consent, who have not given the general consent, alongside your West Bengal, Telangana, etc., 9 states have taken away the general consent, which means each time the CBI has to approach the state, get the permission, and then only go in. Had they had general consent, they didn't have to do that. Now, this is where the issue came in, where the states are telling, despite you not given general consent, how was union government putting CBI inquiries on us? Let's see a few things about your CBI. Your CBI was instigated, that is, it was brought in after the recommendations of your Santanam Committee on Prevention of Corruption. It comes under Ministry of Personal Pension and Public Grievances. It is a non-statutory and non-constitutional body. It is governed by your Delhi Special Police Act. The consent of states for the CBI is the general consent that the states have to give if they don't want to time and again give consent for every time. Section 6 of the Delhi Police Act states that the state government can deny consent to the CBI officer. This is what West Bengal is now telling, and 9 other states have also been holding the same thing. One thing with respect to your CBI is, like we said, it is an apex body, investigative body. But recently it has come under your limelight, telling that it has not held up its and it has not held up its bargain as the apex investigative agency, especially when it is trying to deal with your hawala cases, where in certain cases it has not dealt the way it has to deal with, and also most importantly when it comes to let's say the provisions. It is neither a statutory body nor a constitutional body, so the powers are always feeling constrained. One of the ways to strengthen it is at least to make it a statutory body. Okay, so there are multiple issues of single largest opposition party, and then the last would be your Chief Justice of India, if not any judge appointed by the Chief Justice of India panel. So this is how it has to be, they have told. Another way is that they have tried to improve the position of your CBI is, for example, in 2021, your president promulgated an ordinance wherein he increased the term of CBI director by from 2 years to 5 years. Okay, so this is one of the things where they are trying to give them a term, a fixed term. Let's look at some of the questions. What is the basis for establishment of CBI? Constitutional provision, statutory law, resolution of the Ministry of Home Affairs, executive order. It was the resolution of the Ministry of Home Affairs. Okay. What is the source of CBI's power to investigate and prosecute cases? Delhi Special Police Act, Indian Penal Code, Code of Criminal Procedure, Constitution of India. The answer is Delhi Special Police Act. Okay. Which of the following is a measure to enhance the autonomy of the CBI? Bringing the CBI under the Ministry of Home Affairs, granting statutory status to the CBI, increasing the tenure of the CBI director, allowing the CBI to investigate cases without prior approval. The correct answer here is granting statutory status to the CBI. What is one of the primary functions of the CBI? To investigate cases of corruption and economic offences, to provide training to state police forces, to conduct audits of government department, to enforce law and order in the country. The answer is to investigate cases of corruption and economic offences. Here also, one of the hitch that your CBI faces is if, for example, it has to investigate any of the central government employees, then it cannot do without the permission. So again, here it is not able to effectively bring in things under your corruption. Okay. The next topic we will be discussing is a comparison between Constitution of India and France. Wherein again this topic came in because your France president accepted the resignation of your prime minister and has told them that he can continue to be the head of the government until a new prime minister is appointed. Okay, so we will be comparing the Constitution of India and France, wherein both India and France were a monarch a was under a monarchy, then they become a republic. Understanding? Especially India was very much inspired by your French. Uh, your India was very much inspired by a French Revolution, where, for example, your Tipu Sultan planted a tree of liberty in his capital, Serirangapatnam, and also he called himself as Citizen Tipu. And the ideals of liberty, equality, fraternity was very much inspired. So we even have it as a part of our constitution, the basic ideals. Your constitution, if you see for the France, they've had almost five constitutions up until now. The present one that they are having is the Fifth Republic adopted in 1958. Both are constitutions, that is both India as well as France constitution are written constitution. Both of them operate under the ideals of universal adult franchise. Both of them have bicameral parliament, that is your upper house and lower house. Both of them have the provisions for emergency. Understanding? But one, we saw the similarities. The differences, if you see, that is with respect to the head of state. In India, let's say the president is not directly elected by a universal adult franchise, is more of indirectly elected. Whereas if you see in France, both the president as well as prime minister are directly elected by a universal adult franchise. Whereas here only the prime minister is elected by the universal adult franchise compared to the president. So this is one of the changes that you will see, or the differences that you will see with regard to your India and France. If you see the parliamentary, if you see the parliamentary form with regard to India and France, India is completely parliamentary form, federal in structure, unitary features. France, it is semi-presidential because both of them, both president and prime minister, are elected by a universal adult franchise. Okay. Now let's look at some of the questions. Which of the following is a similarity between the Constitution of India and France? Both have parliamentary form of government, both have presidential form of government, both have bicameral legislature, both are based on the principles of liberty, equality, and fraternity. Okay. Yes, in this, what for this I will not answer. I want you guys to comment the answer in the comment section below. All right. This is just what we discussed. The summation of what we discussed is this question. Okay. I want you to comment this answer in the comment section. Next, what is the key difference between Constitution of India and France? Look at this. They are asking for difference. India has a parliamentary form of government while France has semi-presidential system. India has a federal structure while France has unitary structure. No, both have federal. India has a bicameral legislature, France has unicameral. No. India has a written constitution, France is unwritten. No. The answer is India has a parliamentary form of government while France has semi-presidential form of government. Which of the following is a similarity between the India and French presidents? Both are elected by direct universal suffrage. Both have the power to dissolve the lower house of the parliament. Both have the power to appoint prime minister. Both have fixed term of office. The correct answer is both of them have the power to dissolve the lower house of the parliament. Next, we will be looking into your cabinet committees. Your cabinet committees have been established under your transaction of business rules of 1961. We have appointments committee, economic affairs, political affairs, parliamentary, accommodation, security, investment and growth, skill, employment and livelihood. Among this, the top three, the appointments, economic affairs and political affairs are headed by the prime minister, whereas your parliamentary affairs are headed by your home minister. Okay. Now, coming to your questions. Under which rules are cabinet committees constituted in India? Rules of Business 1961, Transaction of Business Rules 1961, Cabinet Committee Rules, Government of India Rules. The answer we discussed just previously. Transaction of Business Rules of 1961. Under this, cabinet committees are constituted in India. What are the two types of cabinet committees in India? Standing, ad hoc, permanent, temporary, formal, informal, constitutional, extra constitutional. Answer is standing and ad hoc committee. Understanding? Next topic that we will be looking into is constitutional morality. What is constitutional morality? In simpler words, it is a balance between your freedom and restraint. The difference between what I can do and to what extent I can do what I want to do. Understanding? The Supreme Court has very much held that constitutional morality is important to be adhered to, because then it will be not just in letter but in direct following of the principle of constitutional norms. This term was constituted by your British historian George Grote. Okay. B.R. Ambedkar has held that constitutional morality is very much important for the working of the constitution, and at the same point of time, he also goes on to tell that the constitutional morality is not something that comes naturally, but it has to be inculcated. Understanding? So, for the inculcation of this constitutional morality, what constitutes main aspects under it? For example, your fundamental rights, fundamental duty, and separation of powers. Yeah, look at this. Supreme Court in your Krishnamurthy case emphasized that constitutional morality is essential for good governance. In Justice K. Puttaswamy case, it reiterated that its duty to uphold the constitutional morality by nullifying a law that contravenes that In Navtej Singh Johar case, court emphasized constitutional morality over societal morality, while it had to strike down section 377 of the IPC. Let's look at some of the questions. What is the primary purpose of constitutional morality in India? To uphold the principles of constitution, to promote individual rights and freedom, to ensure the rule of law and justice, to protect the interests of majority. It is to uphold the principles of the constitutions. Why we need constitutional morality? Which of the following is a key feature of the constitutional morality in India? Separation of powers, judicial review, fundamental rights. The answer is all of the above. Understanding? This is what we saw with respect to Justice K. Puttaswamy case also. What is the significance of the preamble to the Constitution of India in relation to the constitutional morality? It sets out the objectives of the Constitution. It provides a framework for interpreting the Constitution. It establishes the principles of constitutional morality. It outlines the duties of citizens. The correct answer is it establishes the principles of constitutional morality. What is the relationship between constitutional morality and rule of law? Constitutional morality is a subset of the rule of law. Rule of law is subset of constitutional morality. Constitutional morality and rule of law are interchangeable terms. Distinct concept. The answer is a constitutional morality is the subset of the rule of law. Okay. Last we will be seeing with your Article 341, wherein recently the Supreme Court struck down your Bihar government trying to include economically weaker section into your scheduled caste list. So Article 341 speaks about your scheduled caste list, and your state government cannot meddle. That is, your state government cannot eliminate or add into that particular list. We will learn more about this with respect to the questions. Who has the authority to specify the castes, races, or tribes that shall be deemed to be scheduled caste in relation to a particular state or union territory, and how is it done? President through a public notification, Parliament through a law, Governor of the state through a gazette notification, Supreme Court through a judicial order. The answer is President through a public notification. Okay. What is the process for including or excluding a caste, race, or tribe from the list of scheduled caste specified under Article 341? President can amend the list through a public notification. Parliament can amend the list through a law. Governor of the state, Supreme Court. The answer is Parliament. The Parliament can amend the list through a law. These two are very important differences. That is why I am giving to you in the form of questions. Can a state government make changes to the list of scheduled castes published under Article 341? Yes, with approval of President. Yes, with approval of Parliament. No, state government lacks the authority, only in consultation with Governor of the state. The correct answer is no, the state government lacks the authority to make the changes. Okay, that's it. We've reached the end of the content. If you like our content, subscribe to our channel, hit the like button and share it along with your friends. Thank you.